Hi, everybody. I'm Professor Carter Snead from the University of Notre Dame, where I'm a professor of law and also the director of the Nicola Center for Ethics and Culture. In my area of writing and teaching and research and public advocacy and advice is public bioethics, the governance of science, medicine, and biotechnology in the name of ethical goods. And one of the central questions in public bioethics, that is the point of connection between the law and public policy and bioethics, is abortion. And one thing that is the law and policy of abortion. What should the law and policy of abortion be? How should we govern ourselves in a representative democracy such as the United States of America and in our separate states and communities? One point I'd like to make before giving you the sort of 5 things you need to know about Roe v. Wade and American abortion jurisprudence. So I'd like to underscore the proposition that law and morality are always intertwined with each other. You'll sometimes hear people say, oh, keep your laws and your morality separate and distinct. But to understand what law is to understand that dichotomy is really impossible to sustain. And why is that? It's because all law aims to promote some good or to avoid some evil. So all law is irreducibly normative. Law aims to bring about certain kinds of goods and avoid certain kinds of harms. And those goods and harms are irreducibly normative. You can't avoid questions of justice, questions of morality. Now, that's not to say that every moral question needs to be governed by the law, but it does mean that every single law that you all encounter and that I encounter in our daily lives is rooted in some kind of moral vision about what's good and what's bad, what we should do, what we shouldn't do, what the law should promote and encourage, and what the law should discourage or even punish. So law and morality are inextricably intertwined, and the only coherent understanding of law is one that accepts this reality. And the richest way to understand law is to try to drill down into the foundation of legal doctrine and legal policies and ask the question, what goods are these laws aiming to promote? What harms are they aiming to avoid? That way we can measure for ourselves whether there's a good fit between the purposes of the law and the means of the law. But we can also make deeper criticisms and say, well, the purposes of the law here are actually not good purposes, or they are good purposes. So please don't be mistaken, as many non-lawyers and non-law professors are, by thinking that you can maintain separation between law and morality. Every law without exception is irreducibly normative. It's grounded in a particular moral vision. It's grounded in a particular conception of justice. There's no way around that. And I would say even more deeply, because what law aims to do is to promote the flourishing and protection of persons, all law has to have an operating premise or assumption or set of assumptions about what a person is and what human flourishing is. And we can drill down even more deeply into the foundations of the law to ask the question of what vision of human identity and human flourishing, what some people refer to as anthropology, what human anthropology is animating the law in whatever domain we happen to be considering. And public bioethics is an important domain to ask those questions. Okay, so American abortion law is a creature of Supreme Court decision-making. Okay, most law in this country is made through the deliberative processes of the political bodies, the political branches. At the federal level, that's the U.S. Congress or the executive branch headed by the President of the United States, but also composed of many administrative agencies that make rules and take actions that have the force of law. Think the FDA or the Department of Health and Human Services, and similar bodies. And then, of course, at the state level, we have state legislatures and we have state executive branches headed by the governor of the separate states. Usually, when we govern ourselves and when we pass laws and we adopt legal structures to govern human behavior, we do it through the political processes. However, in 1973, in a 7-2 decision, the United States Supreme Court declared, and it was surprising to many people on the left, right, and center of the political spectrum, declared that it was really the Supreme Court's role to govern the question of abortion, because it read the U.S. Constitution as having a right, an unstated, unwritten right to abortion that the states had to respect, and it was a very strong right, and that the court was going to invalidate any laws that interfered with the right to abortion. So the first point of 5 that I'll make about what you need, 5 things you need to know about Roe v. Wade and abortion jurisprudence in America, is it was basically a naked power grab by the United States Supreme Court that transformed the entire legal landscape in a way that has never been repaired. To take a step back, the role of the Supreme Court in our federal system of government is to interpret the law, right? Is to interpret the law and interpret federal laws and to explain what the meaning of federal laws are, laws that are drafted and passed by the Congress and signed by the president. But also the Supreme Court's role is to interpret the Constitution and to read, and especially the rights and privileges that individual citizens have or individual people have in this country. The Supreme Court's role when the state, either at the state level or the federal level, the government interferes with those rights, the Supreme Court will declare that that state action, the state level action or the federal level action, the governmental action is unconstitutional because it interferes with a particular right that we have as reflected by the Constitution itself. But the limit of the power of the Supreme Court, which is why it was referred to historically as the least dangerous branch, their only authority is to read the Constitution and to interpret its meaning. And the Constitution is a document, right? It's a document that was originally adopted in the latter part of the 18th century and was modified over time in both the 19th and the 20th centuries. And so the question you might ask is, well, why is it that the Supreme Court thought that it had the authority to be essentially the sole arbiter of the law of abortion in America? What part of the Constitution gives it that authority? What part of the Constitution creates a right to abortion that is that the Supreme Court recognized and the states and the federal government have to adhere to? And this is what I mean when I say it was a naked power grab. There is nothing in the Constitution at all, in its text, history, or tradition, that on its face, or even in its historical context, creates or implies a right to abortion. So how did the Supreme Court decide that there was such a right to an abortion? Well, let me bring up briefly for you the provision of the Constitution that the Supreme Court purported to interpret in discovering a right to abortion. I'm going to share my screen with you here. Share my screen with you. And so here it is. I'm going to share it. Now, this is the provision at issue here is a part of the 14th Amendment. It's also largely reproduced in the Fifth Amendment. The 14th Amendment binds the states. Okay, the Fifth Amendment binds the federal governments. But in Roe v. Wade, they read this language: "No person shall be deprived of life, liberty, or property without due process of law." That's called the Due Process Clause of the 14th Amendment. And the court said that language right there, that no person shall be deprived of life, liberty, or property without due process of law, means that there is a right to privacy that is unstated, that is unenumerated, and that right to privacy includes the right to abortion. Now, there was a case from 1965 called Griswold versus Connecticut about Connecticut law that forbade married couples from using contraception, and in that case, the Supreme Court announced that it had discovered a right to privacy in the 14th Amendment on the grounds that even though that's merely procedural language, even though the language itself of the 14th Amendment says that the state can't take your life, liberty, or property without due process, it implies a substantive right to privacy, even though the word privacy doesn't appear there. And then that privacy includes the right for married couples to use contraception without interference from the state. Well, in 1973, the court built on that right to privacy and said, okay, well, that right to privacy also includes the right to abortion as well. Now, to understand how extreme and strange that decision of the Supreme Court was in interpreting that language, you have to understand the context in which the 14th Amendment was ratified. The 14th Amendment was ratified in 1868 by the separate states in the wake of the Civil War to try to create legal conditions that remedied the terrible evils and injustices of chattel slavery. And so their 13th, 14th, and 15th Amendments were designed to try to restore the justice that had been transgressed by our practices of chattel slavery from the founding up until that point, after the Civil War. And no one in America thought that 14th Amendment, that due process language, nobody thought that that was creating a right to abortion. And that's evidenced by the proposition that abortion was illegal in almost every state when the 14th Amendment was ratified in 1868. And in fact, months after the Ohio state legislature ratified the 14th Amendment, they criminalized abortion from conception through birth on the grounds that it was child murder. And no one in the Ohio legislature or anywhere else in the country thought that that was unconstitutional. The very same people who had ratified the 14th Amendment believe that unborn children should be protected by the law. So, and it wasn't until 1973 that the court said, oh yeah, well, that language, which has never historically had anything to do with abortion, which was ratified by states that had banned abortion, that actually implies a right to privacy that includes a right to abortion. So that was a very, very aggressive and lawless act on the part of the Supreme Court. And that's the first thing that I would say that you need to know about Roe v. Wade, is that it was a lawless act, a naked power grab by the Supreme Court without any roots in the text, history, or tradition of the United States Constitution. And in fact, there were even very liberal and progressive commentators who at the time, who in the 1970s were astonished and shocked that the Supreme Court did this. But because there was widespread support in the legal academy for abortion rights, it wasn't remedied by the court at that point. Although it did fan into life the Right to Life movement, which is a civil rights movement, a movement that is aimed at promoting the rights of the unborn child, the flourishing and protection of the unborn child, but also the flourishing and protection of the unborn child's mother and others whose lives have been touched and damaged by the practice of abortion. So, point one, Roe v. Wade is a naked power grab with no roots in the Constitution. Point two, Roe v. Wade brought about a regime of abortion regulation that is the most permissive and extreme in almost any country in the world. Roe v. Wade, even though it had this very strange trimester framework where they purported to regulate abortion in different ways at different stages of gestational development, the bottom line was, because of a case called Doe v. Bolton decided the same day, that no restriction on abortion would be permitted if it interfered with a woman's health, and health was defined in Doe v. Bolton as relating to any aspect of a woman's well-being, not just her physical well-being, not just her emotional well-being, but also her economic and familial well-being also. So you don't need to be a lawyer to recognize immediately that if every restriction on abortion can be overridden by an abortion provider who asserts some aspect of a woman's well-being, that a certain aspect of a woman's well-being would be served by abortion, that really every restriction on abortion will be struck down. Some commentators refer to this as the abortionist's veto, because Doe v. Bolton and Roe vested the authority in the abortion provider himself to make the judgment about when a woman's health, broadly understood, warranted abortion. So that means effectively that there can be no absolute restrictions on abortion throughout 9 months of pregnancy in the United States of America because of Roe and Doe v. Bolton. And that makes us arguably the most extremely permissive legal regime for abortion in the world. And that means that countries in Europe and Northern Europe, Scandinavia, France, Germany, other countries that are far more progressive overall than we are more restrictive when it comes to abortion, because they impose gestational limits that we don't have. We don't have gestational limits on abortion because of the definition of health from Doe v. Bolton. Another is, so that's number two, the legal regime that Roe v. Wade and Doe v. Bolton ushered in is the most extremely permissive pro-abortion rights regime in the world. I would say the third thing that I would like to note for you all is that the right to abortion in Roe v. Wade and Doe v. Bolton, these cases do not grapple seriously with the human identity of the unborn child. You'd think, because in the public debate about it, the debates about sort of when life begins and when we should respect human life and protect human life in the law. Now, the question, of course, and I'll share my screen again here real quick. the question of when life begins as a biological matter is not a complicated question. In fact, any embryology textbook that you would consult would show you the following: that life begins, the life of the human organism begins at fertilization. At fertilization, you have a newly conceived, separate, distinct human organism, member of the human species, who moves him or herself along a species-specific trajectory of gestational development, and is not part of the mother's body, is not a clump of cells, but in fact is a living human organism, as you can see from this diagram, the Carnegie stages of human development. The human embryo, the teachings of modern embryology, the embryo and the fetus are organisms of the species Homo sapiens. They're unique, self-directed, integrated, living human beings who, if all goes well, will move herself along a seamless trajectory of species-specific developmental stages, and the life of the human being begins at conception, okay? But the Supreme Court in Roe v. Wade purports not to take a position on that question, not to take a position on the question of the moral status of the unborn child, and doesn't do the hard work of arguing why certain members of the human family, certain living members of the human species, namely the unborn child, should not be recognized in the law as persons. They wave their hand and say, okay, well, the word person in the 14th Amendment doesn't refer to unborn children, because in the handful of other places in the Constitution where the word person is used, it only applies postnatally, but that's not a very systematic or rigorous mode of terminological interpretation. The court is basically just making a conclusory statement about persons without doing any historical research, without doing any. In fact, Roe v. Wade came to the Supreme Court without having had any evidentiary hearing at all at the trial level, without having any historical analysis. Everything the court says in Roe v. Wade is entirely a function of the justice's own research and writing, untested by the adversarial process of the trial for truth and reliability. So the Roe v. Wade leaves out entirely what exactly who exactly the unborn child is. It says we don't take a position on that. That's a hard question. People disagree about that, even though it's not a hard question as to when life begins as a biological matter. What people disagree about is whether or not some human beings are entitled to the protection of the law, only some, or are all human beings entitled to the protection of the law. And the pro-life proposition is that everyone is protected by the law, regardless of who he or she is, where he or she might be, how vulnerable, dependent, small, vulnerable he or she is. The law should protect him or her no matter what. That's the pro-life proposition. The pro-choice proposition is that only some people are entitled to the protection of the law. That is, only people who are strong and privileged and outside of the womb, and who can speak and represent their own interests. So at the same time as the court was arguing that, was claiming to argue that they were not going to take a position on the moral status of the unborn child, they were very clear that they were motivated in finding this right to abortion by reflecting on the burdens to a woman of an unplanned pregnancy. And of course, these are real burdens. They're burdens that we in the pro-life movement should work hard to alleviate. We should accompany women in their situation. We should serve them and help them, and as a community help them, as a nation help them, as the government should help too. But what the court looked at, and they sort of atomized the woman and her suffering. They made her a kind of a radical individual and said, okay, well, it's not just the pregnancy itself that's burdensome, but also the fact that being a parent once the child is born is burdensome. So the court, in enumerating all the burdens on the woman, included not just physical health or emotional health. It talked about childcare and distress for all concerned associated with an unwanted child. The problem of bringing a child into a family unable psychologically to care for the child. All of these are factors, the court said, that motivated it to discern that there was a right to abortion. And it basically framed the question of the human context of abortion in a really unrecognizable way. It didn't say this is a dispute between a mother and a child and in an extremely complex, interrelated human scenario. It simply said it described the mother and the unborn child as isolated strangers, as adversaries fighting over scarce resources. And that right there, that's not an accurate or descriptive, fairly descriptive account of what a human pregnancy is. A human pregnancy is a mother-child relationship, intertwined and sui generis. That is, unlike any relationship that we experience in life, when the mother is literally the only source of life support for the baby. The baby is entirely dependent upon her mother. Their lives are completely integrated and intertwined. Yes, it's a complicated question. Yes, it's very difficult, but we can't ignore the fact that what we're talking about is a conflict or a crisis involving a mother and an innocent child. And once we frame the question that way, then we can reason clearly about what we should do in the face of this kind of a crisis. But if we say these are merely strangers fighting over scarce resources that happen to belong to the body of one of the two parties who we recognize as a person, the other we recognize as essentially something subpersonal, well, then you're going to get essentially a right to kill and to unburden yourself, which is precisely what the court did in these cases. Okay, so the court has an inhuman framing of the crisis in which the abortion question arises by not taking seriously the human identity of the unborn child, not taking seriously the interrelationship, the inextricable intertwining of the lives and fates of mother and child, or the familial context, that it's a mother and a child involved. It's not two strangers. Okay, so the fourth thing I would say about that you need to know about Roe v. Wade and abortion jurisprudence is that Roe v. Wade is not, in fact, the law of the land relating to the question of abortion. In 1992, it was replaced by a case called Planned Parenthood versus Casey, which abandoned the trimester framework, which I haven't really talked about because it's not important because it was superseded by Planned Parenthood versus Casey, and replaced by a framework that says before the child is viable, that is before the child's lungs are sufficiently developed to live outside the mother's body, prior to that moment of viability, the state may not unduly burden a woman's right to abortion, but after viability, the states can restrict abortion. And on its face, this looks like a loosening up of the law of abortion under Roe v. Wade. However, because Planned Parenthood versus Casey did not abandon the definition of health or the precedent of Doe v. Bolton, it's still true that no matter at what point in pregnancy the law regulates, if an abortion provider certifies that it's in the woman's well-being, in the interest of her well-being, to get an abortion, and not just physical, not just emotional, but also economic or familial well-being, then the health exception of Doe v. Bolton applies and the law has to give way. So it's still the case, even though Planned Parenthood versus Casey is the standard, is the Supreme Court precedent for abortion in America that governs the question of abortion in America. It is still very extreme because it did not get rid of the proposition that at any stage of pregnancy, if the abortion provider believes the abortion would advance the well-being of the woman, broadly understood that she should have, as a matter of constitutional right, have access to that abortion. So Planned Parenthood versus Casey is the decision from 1992. Again, it has the undue burden standard for pre-viability abortions. Still, the court's still kind of working out what that means, what constitutes an undue burden. And unfortunately, what happens is a state passes a law regulating abortion, even in a very minor way. Let's say it's a regulation on abortion saying you can't get an abortion solely for the sake of eliminating the life or preventing the birth of a child with Down syndrome, or you can't get an abortion solely for the sake of eliminating a child of a disfavored sex or a disfavored race, for example. Or let's say there's a law that says you can't perform an abortion of a particular kind, a particular procedure that is grisly and violent, and eliminating one particularly controversial abortion procedure while allowing abortion, but not allowing that particular procedure. Once a state passes one of these laws, it has to go through the entire the litigation process, starting at the federal trial level. It goes up to the federal appellate court, and it usually takes about 2 years to get to the Supreme Court. And then the Supreme Court tells you yes or no, is this law an undue burden on the pre-viability abortion, or is this law, even if it applies post-viability, not allowed because it interferes with some aspect of a woman's health, meaning her well-being, including economic or familial well-being. So it's extremely cumbersome. Essentially, the court since 1973 has taken it to itself to be the abortion control board for the entire country, even though there's no warrant or justification for that in the Constitution. So this brings me to my fifth point, which is, well, why hasn't Roe v. Wade been overturned? Why hasn't Planned Parenthood versus Casey been overturned? And I will say that very few jurists will defend Roe v. Wade and Planned Parenthood versus Casey as faithfully flowing from the Constitution itself. They don't really argue that the 14th Amendment, they will argue it, but they don't spend a lot of time focusing on the proposition that the right to abortion can be fairly read into the Constitution itself, the 14th Amendment Due Process Clause. What they argue instead, and what you probably have heard in the debates over Supreme Court nominations and others, is that the principle of stare decisis requires the court to maintain these precedents, these past precedents, even though they are not, maybe were wrongly decided in the first instance. That is, even though these might be wrongly decided, even though Roe v. Wade might be wrongly decided, we have to maintain it because the doctrine of stare decisis requires us to. And the doctrine of stare decisis is a proposition. It's a rule of prudence that judges are invited to consider when they are thinking about overturning a prior precedent. It doesn't mean that every prior precedent has to stand. It just means that before you overturn a prior precedent, you have to consider the practical consequences to doing so. And there's a kind of series of considerations the court has to look to. They ask the question is the prior precedent practically unworkable? They'll ask, has there been a large population of people who have come to rely on that prior precedent? Has the prior precedent, does it represent a doctrine that's been abandoned, or have the facts so changed that it makes sense to undo the precedent? If the answer to all those questions is yes or no, depending on the question, then the court says, all right, we're going to overturn the prior precedent, right? And so the argument for sustaining Roe and Casey is that, well, so many people have built their lives around the right to abortion that to undo it would be so disruptive of our society that we can't do it. It would be irresponsible to undo the right to abortion, to be undue. Now, this is an argument that on its face persuades a lot of people, but when you really dig into the facts and the law, it doesn't make much sense. First of all, Roe v. Wade and Planned Parenthood versus Casey are impractical. As I just said a moment ago, it requires the Supreme Court to sign off on every single law that relates to abortion everywhere in the country, a process that is cumbersome. It changes. It really takes up a lot of the court's time. It creates instability in the law. It's not workable to have the court have to be the final arbiter of the right to abortion, especially since the right to abortion is in fact not in the Constitution itself. Okay. Point two, and this is another point, is that it has not been demonstrated ever that a large group of women have built their lives in reliance on the right to abortion. And if somehow the court were to overturn its prior precedent, that women would no longer be able to compete and live their lives on an equal basis in the social or economic dimensions of our nation's of our current environment here in the United States, right? That somehow it would set women back dramatically if they didn't have the right to abortion. Well, that's never been shown to be true. And in fact, the opposite has been demonstrated by social scientists like Michael New at Catholic University of America, who shows that in those jurisdictions where abortion is more restricted, women's flourishing, socioeconomic flourishing and freedom is not any less than it is in those jurisdictions where abortion is widely permitted. In fact, there may be an inverse relationship between those two things. But the deeper point here, though, I think, is to say that what abortion involves is the intentional killing of an innocent human being. And even if it were somewhat disruptive, even if it did create an upheaval in the legal and political fabric of our nation, it's something that we have to do. And the same thing in the name of justice, because segregation, undoing segregation with Brown v. Board of Education, would, of course, created a massive amount of people. Requiring the South to desegregate was enormously burdensome to the South. It turned their lives upside down in many ways, but it was the exact right thing to do, because it was unjust and shameful that these parts of our country had legalized discrimination against our African-American brothers and sisters. Okay. We had to do it because it was the right thing to do. And the stakes were so high, and the stakes are equally high here in the context of abortion. We're talking about killing innocent unborn children on about 1 million a year. And there's another reason why the stare decisis argument, especially the reliance argument, doesn't add up. And I'll tell you why. It's because if Roe v. Wade are overturned tomorrow, what would happen is the law of abortion would revert back to the political branches. It would be resolved by the states according to the political process. There would be discussion and deliberation and possibly compromise and different parts of the country. And this is what we call federalism. Each state is allowed to pursue its own vision of the law. And in fact, some justices have heard to the laboratories of the state, see what works and what doesn't. And some jurisdictions would adopt abortion law that is coherent with the preferences of that population in that state, and other states wouldn't. And for better or worse, that would be the situation. It would not disrupt this. It would not disrupt the lives of Americans, and it wouldn't create circumstances of injustice. Overturning Roe v. Wade and Planned Parenthood versus Casey would not automatically criminalize abortion across the United States, because the grounds on which it would be overturned would almost certainly be that there's no warrant for abortion rights in the Constitution itself. So, will that happen? Only time will tell. We have 6 justices on the Supreme Court who are appointed by Republican presidents who pledged to appoint justices who would not legislate from the bench, and there's a sort of judges that are not inclined to legislate from the bench are judges that are inclined to recognize that there's no right to abortion in the Constitution itself. So it'll depend on how those 6 justices view the question of stare decisis, and it'll depend on what kind of case comes to them, and whether it'll be incremental or all of a sudden. But I think the odds are that, given the current composition of the U.S. Supreme Court, that Roe v. Wade and Planned Parenthood versus Casey may very well be overturned in the near future, and that would create a political question for jurisdictions around the country to settle that through the political processes. Okay, that's point number 5. What happens if Roe v. Wade's overturned? Why hasn't it been overturned? I'll leave you with this. Okay, so the important thing, in addition to knowing what the law is and knowing what the arguments are for the intrinsic equal dignity of every human being, which is at the core of the pro-life idea, that everybody counts, everybody matters, we have to, those of us who are arguing for the unborn child and for the dignity and equality of their lives, we have to witness to that commitment in our interactions with others, including especially those we don't agree with. So when we talk to people we don't agree with, when we are being observed by people we don't agree with, we want to comport ourselves and behave in a way that is consistent with our deeply held view that everybody matters, everybody counts, including the weakest and most vulnerable, and that we're at our most human and we're at our best when we're taking care of each other. So that kind of radical love and radical hospitality and unconditional love for others is going to change hearts and minds even more than elegant and persuasive arguments. So thank you very much for your time, and I appreciate you paying attention, and God bless you, and take care of yourselves and each other.